Hello and welcome to today's webinar on ending co-ownership fairly, specifically on partition accountings. My name is Elaine Huang and I am an attorney here at Blake Law Firm. And this is one of my favorite topics to work with and as well as speak on. So I'm very excited today to get on to speaking the nuances of partition accountings. And to start off, let's discuss what is a partition action. This is the set of real estate law that allows a co-owner to forcibly end a co-ownership without the need of the other co-owner to agree. In California, it is an absolute right of one co-owner to request the end of the co-ownership should they wish. Whether it is a residential property or a commercial property, a co-ownership holding title has the absolute right to ending that co-ownership should they wish to seek the court's involvement. And when the court gets involved with a partition action, oftentimes one of the big issues that needs to be settled are the expenses. Co-owners that have spent a bunch of their money on improvements, paying for a mortgage, maybe one co-owner has collected more rent than the other, is one of the frequent scenarios that leads co-owners to disagree on how the co-ownership ends. And therefore, a lot of the time, the dispute is not in whether the co-ownership needs to end, but how will it end and who will leave with how much money. In that regard, an experienced partition attorney who has worked with the various categories of expenses will be your best asset to help you maximize your financial recovery, because a partition attorney who's familiar with accountings can tell you most of the time your expense for paying the mortgage, paying for the interest on a loan that benefited the property, such as a refinance, or paying for improvements that directly preserve the property itself, will be entitled for recompensation during the accounting process of a partition. But if you don't know what you're entitled to, you may not be able to recover it, which is why an experienced partition attorney could be your best asset in that scenario. Let's get into a bit deeper of what is a partition accounting. So under Civil Code CCP 872-140 specifically, the court is given the authority to adjust the amount a co-owner is entitled to. So for example, you have two co-owners who are 50-50 owners. Naturally, the end of the co-ownership would mean that the parties each are entitled to 50% of whether it's the burden of the expenses or the benefit of income, such as from collecting rent. Now, that doesn't mean in every single scenario, a 50% co-owner would leave with 50% of, for example, the sales proceeds after selling the house. And that is because the courts have the authority to adjust and give a disproportionate share to a co-owner based on an equitable contribution. So for example, the court may look at how one co-owner has paid for 100% of the mortgage, whereas the other has been collecting 100% of the rent. When we get into the partition accounting part of your partition case, that is when each co-owner will do a balancing of the equities and look at how much a 50% owner should have been paying, and if that 50% owner paid more than 50%, for example, this is when they can claw it back on grounds of equitability. And the principle is the co-owner who paid more than their percentage of the ownership was advancing those funds in order to preserve the property. If the mortgage wasn't paid or the roof wasn't fixed because that co-owner refused to advance those funds, then the property may be in jeopardy. The property may be foreclosed on. So there is this doctrine of equitability allowing the court to adjust disproportionate payments in the past so that when the co-owners leave this co-ownership and the property is sold or bought out, the amount each co-owner is paying or getting paid from the sales proceeds are equitable. So next, we'll look into some of the expenses that are equitable in partition accountings, because the general rule is these expenses we're about to talk about preserve the property. For one, as we just mentioned, mortgage payments allow the co-owners to preserve the title. They also protect the property from being foreclosed on. So mortgage payments are essentially a no-brainer. If co-owners have been paying more than their percentage of the co-ownership. For example, if you're a 30% co-owner and you've been paying 70% of the mortgage payments, that's a great area to ask for partition accounting reimbursements in. Then there are property taxes, which just like mortgage payments, if you're paying them, it keeps the title free and clear of any liens. So in that situation, you're preserving the title and keeping it clear. And then there are insurance premiums such as fire insurance, general liability insurance at a commercial property, for example, that may be required. And paying for these insurance premiums are also one of the categories that will certainly be reimbursed if one co-owner is paying more than their share. Lastly is repairs or property improvements. Generally, the rule of thumb is when the repair or the improvement preserves the property, such as fixing a roof, building a fence, repairing a glass window, those are property improvements that will be reimbursed if one co-owner pays above their co-ownership interest. However, there are some discretionary choices by co-owners that aren't guaranteed to be reimbursed. For example, if your co-owner who is not a contractor, who has no experience with painting or repairing drywall, chooses to conduct their own repairs, paints the house bright pink, and chooses bright orange shingles for the house due to their discretion, it isn't guaranteed that the court will make you reimburse them, because it's possible that there is an argument those expenses were not to preserve the property. A pink wall and an orange roof may not increase the property's value or preserve the property's state. So it's possible that if you have an experienced partition attorney, they can help you deny claims from your co-owner that are unreasonable and save you money in that regard. Next, we'll take a look at the key legal considerations when we're engaging in a partition accounting. First, as we've discussed, the court does have the authority to adjust the contributions among the co-owners. And what that usually looks like is that the property will sell or the co-owners will agree to a buyout, and then the attorneys can file a motion for the court to determine the offsets. The attorney who submits the brief on behalf of their client should be prepared to provide receipts and other documentation of evidence showing that the money was actually spent. So, for example, if your co-owner alleges that they spent $11,000 on building the fence outside the property, if the fence is clearly there, that is one level of giving evidence. But the court may not be able to determine that the fence that was built improved the property a value of $11,000. Whereas if you have a photo of the invoice from the contractor showing your client paid $11,000, then your brief for the court to determine that your client deserves $11,000 for that contribution is a lot stronger. So a huge part of partition accountings is being prepared and having your evidence organized, because that is the best case scenario in order for your client to get a reimbursement, you need to persuade the court that the money was spent and that it was truly a improvement that preserved the property's value. If you have an old fence from 11 years later that looks pretty torn down and we're not sure what the quality of the fence was in the first place, you may give your co-owner room to dispute that reimbursement request. So it's very important for the co-owner to keep in mind the goalpost of whether or not my expenditure preserves the property, and two, how can I provide the most persuasive piece of evidence to authenticate that the money was spent to preserve that property. And now we're going to talk a bit about how that accounting unfolds. We previously discussed briefly that the attorney can file a motion and ask the court to determine the offsets. These are other potential routes of resolving a partition accounting. For one, if the co-owners are in agreement, they can stipulate. After an informal exchange of invoices and negotiations, the co-owners may decide it's cheaper and it's faster to stipulate to an accounting. If agreed to by the co-owners and the judge signs off on a proposed order, you're essentially golden and you've skipped over that process of having the court review all of your receipts and make a decision from there. Next is if you aren't able to agree with your co-owner, you don't necessarily have to resort to the court making a determination either. In many partition disputes, there is a partition referee who has been appointed to sell the property if that is the route the co-owners have agreed to. That partition referee can be given the power to determine the offsets. Of course, that partition referee doesn't have the final decision-making ability because the court does still need to bless the accounting, but that referee is able to do a lot of the legwork, such as evaluate the facts, speak to the parties, and give recommendations on how costs should be allocated based on that doctrine of equitability. And lastly, once the referee has reviewed all of the evidence and spoken to the parties, provided his recommendations, the referee is able to provide his own set of opinions that will be given to the court, and that will outline the referee's determination of how much each party should get if there is an equitable distribution after the sale proceeds from the property selling has been completely done. So we've talked a lot about the partition accounting procedure today, and you can see that there are various routes that can occur. Perhaps the co-owners are in agreement after an informal exchange of accounting. Perhaps you have a referee who's in charge of sifting through all the receipts, or the parties can agree that the court is the best venue and the best authority to determine what an equitable reimbursement looks like at the end of the partition accounting. However, none of those steps are as easy and simple as this short video may make it sound if you don't have legal representation who guides you on what are the goalposts in a partition action, what are the values you want to satisfy with your evidence, for example, an equitable reimbursement that preserves your property. And when you're sifting through all the documents yourself, it may be difficult for you to determine what is entitled to a reimbursement. And if you throw all of that into a document in an unorganized fashion, it may be a very long time before the court makes a determination of how much you or your co-owner is entitled to. So rather than wasting time and ultimately wasting your own money, it's best to have legal representation that is familiar with partition accountings. Partition attorneys who do this day in and day out like their bread and butter are so familiar with whether your request for the reimbursement of buying a new oven is reasonable versus your co-owner's expenditure of buying a new awning is reasonable. So just these small nuances are so important to figure out, and having legal representation who's familiar with those issues will make all the difference in maximizing your share proceeds so that you are reimbursed the amount you are entitled to in an equitable manner. If that sounds of any interest to you, then I am more than happy to speak, and you are more than welcome to send over any questions to Blake Law Firm. We're here and happy to answer any of your questions and ready to engage with you if you have an inquiry on a partition action or a partition accounting. Again, my name is Elaine Huang, and it has been a pleasure to speak with you on partition accountings today, and I hope we have the pleasure to connect in the future. Take care.